Imagine opening your mail, right, and finding a bill for £30,000.
Yeah, that would absolutely ruin your day.
Completely. And it's not a judgment from some criminal court after a long, drawn-out trial, and it's not from a judge.
Right.
This bill is directly from your local city council.
Just dropped right on your doormat.
Exactly. And just as you're, trying to process that, you find out your tenants are legally allowed to demand a full year of their rent back from you.
Retroactively, too.
Retroactively. So if you're listening to this, you are someone who wants to understand the absolute high-stakes reality of property law.
But you probably have, zero desire to wade through hundreds of pages of dense legal jargon to get there.
Oh, absolutely not. I mean, who does? So consider this deep dive custom-tailored for you. Our mission today is to explore the dramatic, escalating enforcement toolkit that local councils in England use against landlords.
We are looking at exactly what happens when the rules are broken.
Right, when the state decides to strike back. So to map out that toolkit, we're looking at the foundational legislation, specifically the Housing Acts 2004 and the Housing and Planning Act 2016, along with a bunch of accompanying regulations.
Which I know sounds very dry.
It really does. Housing regulations usually sounds like an immediate cure for insomnia.
Yeah, but these texts detail the mechanisms of enforcement. They outline a system that is, honestly, incredibly powerful once it gets set into motion.
They secretly contain the blueprints for financial ruin and real courtroom drama. Okay, let's unpack this. I want to start with the financial front lines.
Makes sense.
Because before a council ever tries to take away a physical property, they hit the landlord right where it hurts, the wallet.
Right, and the primary weapon on that front line is the civil penalty.
Okay.
So, historically, if a local housing authority wanted to punish a landlord for a housing offense, say, renting out a downright dangerous property, they had to prosecute them in the criminal courts.
Which means magistrates, criminal standard hearings, the whole process.
Exactly. It was an enormous burden on the local council.
I imagine that takes months or even years to prep for just a single case.
Oh, yeah. The resources required were immense, and it created this massive bottleneck in enforcement because councils are chronically underfunded.
So a lot of bad landlords just slip through the cracks.
Essentially, yeah. They flew totally under the radar. But the updated legislation introduced a streamlined, unilateral alternative.
Which is?
What's fascinating here is how this shifts the battleground. Instead of dragging a landlord through a lengthy criminal court process, the local authority can now entirely bypass the courts and impose a financial penalty of up to £30,000 for a single offense, just directly.
Wait, £30,000?
Up to $30,000, yes.
Just issued by the council itself. I mean, that is staggering power.
It really is.
But surely they still have to do their homework, right? They can't just hand these massive fines out because a housing officer walked by and thought a property looked a bit shabby from the street.
No, absolutely not. The burden of proof remains incredibly high. To levy this fine, the council must be satisfied beyond reasonable doubt that a relevant housing offense occurred.
Okay, so that's the criminal standard of proof.
Exactly, but it's being applied to a civil penalty process. So the housing officers are essentially building a criminal-grade dossier.
Like collecting witness statements.
Witness statements, taking precise measurements, photographing safety hazards. But instead of handing that dossier to a prosecutor, they just use it to justify the fine internally.
Wait, what does a relevant housing offense actually mean in practice? Are we talking about, a collapsing roof or something as minor as an overgrown garden?
Well, it covers a specific spectrum of violations. Failing to comply with an official improvement notice is a major one.
Okay.
Operating an unlicensed house in multiple occupation and HMO is arguably the most common trigger. But it also includes failing to comply with overcrowding notices or breaching basic management regulations.
Let's pause on the management regulations because that feels like a trapdoor.
It can be.
What actually constitutes a management failure according to the sources?
It's remarkably comprehensive. I mean, the legislation explicitly states that a manager must ensure fire escapes are clear of obstructions, the water supply is consistently maintained, and yes, even that the boundary walls and gardens are kept safe and tidy.
Wow, really? The boundary walls?
Yeah. Ignoring a broken fire alarm system or letting a shared property become dangerously overcrowded gives the council all the ammunition they need. They issue a notice of intent, followed by a final notice, and that locks in the penalty.
Wait, £30,000 is a massive hit. Is this just the equivalent of a traffic ticket for a landlord or something more fatal?
How do you mean?
Because if you're a massive corporate equity firm running hundreds of units, maybe you just absorb that cost as a slap on the wrist. But for an average person with a couple of rental properties, a corporate-level speeding ticket of £30,000 could wipe out a year's profit in a single stroke.
Oh, easily. For a smaller operation, it's entirely capable of being a fatal blow to the business.
That's intense.
And the math gets significantly worse if there are multiple violations, because that 30,000 is the maximum per offense.
Oh, wow.
Yeah, so if a landlord is operating 3 separate unlicensed HMOs, they could be facing 3 separate civil penalties simultaneously. The financial burden scales up exponentially.
And from what I understand, the council actually gets to keep the money from these fines.
They do. The legislation specifically dictates that local authorities retain the revenue generated from these penalties.
That feels like a conflict of interest now.
Well, there's a strict stipulation. The funds must be reinvested into further housing enforcement.
That is a brilliant and slightly terrifying piece of legislative engineering.
It creates a self-sustaining loop.
Exactly. The council finds a bad landlord and uses that exact money to go hunt down 3 more.
Precisely.
But civil penalties only enrich the council's enforcement fund. What about the tenants who are actually living in these properties?
That's the next step.
Because what happens if the landlord simply pays the fines as a cost of doing business and refuses to fix the collapsing roof? The council can't just keep issuing tickets while the building burns.
Right. And that logic brings us directly to rent repayment orders, or RROs.
Okay, RROs.
If the civil penalty is the punishment paid to the state, the RRO is the forced refund paid back to the consumer.
I see.
Chapter 4 of the Housing and Planning Act 2016 outlines this. It allows a tenant to apply directly to the first-tier tribunal to force the landlord to pay the rent back.
Or the state can apply, right?
Yes, the local authority can apply if they paid the rent via state benefits like universal credit.
How much rent are we actually talking about here?
The tribunal can order a maximum repayment capped at a period of 12 months.
12 months of rent. I mean, think about how much rent is these days, especially in a city. We are talking tens of thousands of pounds.
Oh, absolutely.
Does the tribunal just automatically hit the refund button for a full year every time a tenant applies?
No. They don't blindly award the maximum. They weigh several factors to determine the final amount.
Like what?
They examine the conduct of both the landlord and the tenant. Was the landlord intentionally dodging the law, or was it a genuine oversight?
Right.
Did the tenant obstruct the landlord from doing repairs? They also look at the landlord's overall financial circumstances, and crucially, they check if the landlord has previous convictions or has already been hit with one of those 30,000-pound civil penalties.
Okay, I have a massive clarification question here.
Go for it.
Let's say a landlord has a house that requires an HMO license under the rules, but they just never filled out the paperwork.
Okay.
However, the house itself is in perfect condition. The heating works, the fire alarms are state-of-the-art, no safety hazards at all.
Right.
Could a tenant legally get a whole year of free rent via an RRO simply because the license was missing?
The short answer is yes.
Wait, really?
Yes. The failure to license a property that legally requires one is a specific offense that triggers the possibility of a rent repayment order.
Even if the house is perfect.
The physical property could be an absolute palace, pristine in every way. But if it operates illegally without the required license, the landlord is entirely exposed. The tenant has the legal right to apply to the tribunal to claw back that rent.
That is mind-blowing. It's essentially a state-sanctioned clawback.
Right.
The government is giving the tenant the legal teeth to sue their own landlord for a retroactive 100% discount just over administrative paperwork.
If we connect this to the bigger picture, you can see the strategic genius behind this mechanism.
How so?
Local councils have severely limited resources, right? They cannot physically inspect every single rental property in their district to check for licenses.
Yeah, that makes sense.
But by offering the possibility of a 12-month rent refund, the state heavily incentivizes renters to educate themselves about housing law and report unlicensed operations.
Wow. It turns every tenant living in an illegal setup into a highly motivated, unpaid auditor for the council.
Exactly. It deputizes the tenants.
I can only imagine the sheer panic of a landlord opening a letter from the tribunal, realizing their tenants have banded together to claw back £40,000 in rent.
It's a very bad day at the office.
But let's look at the limits of these financial tools. Fines and clawbacks are purely monetary. What if a landlord just views these penalties as a high-risk cost of doing business?
Yeah, the stubborn landlord scenario.
Right. They pay the council the $30,000, they refund the tenants, but they still stubbornly refuse to fix a fundamentally dangerous building. The council can't just keep issuing tickets while the property crumbles.
And they don't. When financial leverage fails to achieve compliance, the state moves to physical intervention
Okay, what does that look like?
through management orders.
Uh,
Specifically under Chapter 1 of Part 4 of the Housing Act 2004, we have Interim Management Orders, or IMOs, and Final Management Orders, FMOs.
got it.
This is the ultimate escalation for an unsafe physical environment. The local authority literally takes control of the building from the owner.
Here's where it gets really interesting, because this is essentially a hostile takeover.
That's one way to put it.
It's like the government placing a failing bank into administration, but for a living, breathing apartment block.
That analogy holds up perfectly under the mechanics of the law.
Really?
Yeah. When an interim management order is executed, it lasts for up to 12 months. On the day it goes into effect, the council assumes the complete management of the property.
Just like that.
Just like that. They notify the tenants that all future rent payments must be redirected to the council's bank account, not the landlord's.
Wow.
The council can sign new tenancy agreements, arrange for repairs, and literally change the locks on utility rooms.
And what happens to the actual landlord during this hostile takeover? The person who actually holds the deed to the bricks and mortar.
They're completely sidelined.
They'll just get pushed out.
The legislation explicitly neutralizes their rights. While a management order is in force, the property owner is legally forbidden from collecting any rent from the occupants.
That's crazy.
They cannot exercise any rights to manage the property, they can't negotiate with tenants, or interfere with the council's administration of the building at all.
So they basically just have to stand on the sidewalk and watch a government officer run their investment property.
Yep. They step perfectly into the landlord's shoes.
And I assume the council is using the rent they just redirected to fix all the massive hazards the landlord ignored.
Exactly. The primary function of redirecting that income stream is to fund the property's own salvation.
Right.
The council uses the collected rent to pay for urgent repairs, ongoing maintenance, proper insurance, and their own administrative costs for managing the takeover.
Okay, but let's play out a worst-case scenario.
Sure.
Say the roof is entirely caving in, the plumbing is utterly shot, and the electrical system is just a massive fire hazard.
A total disaster property.
Yeah. The council takes over and collects, let's say, £2,000 a month in rent, but it costs them £40,000 to fix all those structural issues.
Which happens.
What happens when the math just doesn't add up?
Well, the legislation outlines a very strict, unapologetic financial accounting process. When the management order terminates, the books are balanced. If there happens to be a surplus, meaning the rent collected was more than the council's total expenses, that remaining money is returned to the landlord.
Which seems fair enough.
However, as in your scenario, if there's a deficit, if the council's expenditure to bring the property up to a safe standard massively exceeds the rent they managed to collect, that difference becomes a legally recoverable debt.
Are you serious?
Very. The local housing authority will bill the landlord for the shortfall.
Wow. So not only has the council forcibly seized your asset, stripped you of your rights to run your own business, and spent all of your rental income,
Yeah.
they can actually hand you a massive invoice at the end of the year because your property was so dangerously neglected that it cost the state extra to fix it.
It is the absolute total loss of control.
Mm.
And if a 12-month interim management order isn't enough time to resolve the deep-rooted issue.
Or if the landlord is just going to ruin it again.
Exactly. If the council believes the landlord will immediately revert to dangerous practices the second they get the keys back, the council can apply for a final management order.
An FMO. How long does that last?
Up to 5 years.
5 years.
For half a decade, the local authority dictates the management scheme, allocates the funds, and ensures the safety of the occupants, entirely bypassing the property owner.
I honestly can't think of many other areas of private enterprise where the state can legally seize your asset, run your business for 5 years, and potentially charge you for the privilege.
It's rare.
It profoundly highlights that the law views housing not just as a financial asset class, but as essential infrastructure.
Shelter is fundamentally tied to human health, safety, and community stability. The gravity of the legislation reflects that reality.
Absolutely.
But seizing the physical property is still focused on the building itself. If the individual operating the business is inherently unfit, there is one final ultimate sanction.
Right, because taking the house protects those specific tenants, but taking away a person's entire livelihood protects the whole market.
Precisely.
Let's talk about the final step, total excommunication via banning orders.
So, Chapter 2 of the Housing and Planning Act 2016 details this. If a person is convicted of a severe housing offense, what the law categorizes as a banning order offense, a local authority can apply to the first-tier tribunal to have that individual entirely removed from the industry.
Removed from the industry entirely.
Yes. The tribunal can ban that person from letting out housing, engaging in any letting agency work, or performing any property management work in England.
They are completely blacklisted, so they can't rent out the houses they already own, and they can't, like, pivot to a desk job working as a property manager for somebody else's real estate firm.
The ban is comprehensive. The tribunal determines the duration, which carries a mandatory minimum of 12 months, but in egregious cases, it can stretch for years.
And what if they just ignore it?
Attempting to circumvent a banning order is itself a serious criminal offense.
I would hope so.
If a banned individual tries to use a shadow company or simply ignores the order and rents out a property anyway, they are facing imprisonment for up to 51 weeks, an unlimited criminal fine, or yet another £30,000 civil penalty.
But practically speaking, if someone gets banned in London, what's stopping them from just setting up an LLC, driving a few hours north, and buying up a bunch of HMOs in Manchester?
It's a great question.
How do these local councils actually talk to each other to enforce a nationwide ban? Is this like a public name and shame list?
This raises an important question about how the state manages cross-jurisdictional intelligence. The answer lies in Chapter 3, which establishes the database of rogue landlords and property agents.
Okay, the rogue landlord database.
Well, the framework is maintained by the central government. Local authorities are the ones populating it with data. It serves as a centralized surveillance tool for housing officers across the country.
So it stops the whack-a-mole problem. You get shut down in one city, you can't just pop up in another because Manchester can look up your record from London.
Exactly. The intelligence sharing is rigorous. If a landlord is convicted of a banning order offense, the local authority is legally obligated to enter their details into the database. It is mandatory.
Makes sense.
Furthermore, there is a discretionary power that is just as dangerous for repeat offenders. If an individual receives 2 or more financial penalties, like those £30,000 civil penalties we discussed, within a 12-month period, the local authority may add them to the database even without a formal criminal conviction.
Wait, really?
Really?
You don't even need to be found guilty in a criminal courtroom. 2 civil penalties issued internally by a council in a single year, and you can end up on the National Rogue Landlord Watch list.
The threshold is designed to catch persistently bad actors before they cause catastrophic harm. The system ensures that landlords cannot hide behind the fractured geography of local municipal borders.
Wow.
If you demonstrate a severe disregard for housing regulations in one jurisdiction, every single housing authority in England will have visibility on your track record.
So let's pull back and look at the sheer scale of the enforcement ladder we've just unpacked.
It's quite a ladder.
It really is. If you run afoul of these laws, the escalation is terrifying. First, the council hits you with a streamlined £30,000 civil penalty without ever taking you to a judge.
Right.
Second, your tenants realize your paperwork is illegal and use an RRO to legally claw back an entire year of their rent.
Yep.
Third, the council decides you are unfit to maintain the building, executes a management order, physically changes the locks, runs your property, and bills you for the repairs.
Which can take years.
And finally, they secure a banning order, put your name in a national database, and completely exile you from the entire English property market.
It is a vast, heavily interlocking net of enforcement, and the rationale is clear,
Oh.
The consequences of housing disrepair, such as fatal fire safety failures in overcrowded HMOs or dangerous structural collapses, they are devastating.
Truly devastating.
The legislation is deliberately engineered to be deeply punitive to ensure strict compliance from anyone choosing to provide shelter for profit.
And that is exactly why this deep dive is so vital for you to hear. Whether you are a renter trying to understand just how much leverage you actually have against a negligent landlord, or someone casually thinking about buying an investment property for passive income.
It's crucial context.
The property market is not a casual side hustle where you just collect checks. It is a highly scrutinized, heavily regulated industry with severe, life-altering financial and legal consequences for non-compliance. Which brings me to a final thought I want to leave you with.
Please do.
We hear the phrase rogue landlord all the time in the news.
All the time.
It conjures up this vivid image of a cartoon villain, right? A slumlord maliciously exploiting vulnerable tenants, ignoring broken smoke alarms, and greedily counting our cash.
Right, the classic stereotype.
And unfortunately, those people absolutely exist, and these severe laws are custom built to stop them. But looking at the incredibly strict requirements we've discussed today, the complex fit and proper tests, the intricate rules on room sizes, the absolute necessity of holding the correct licenses before a single tenant moves in.
The administrative burden is immense and highly specific.
Exactly. It raises a really uncomfortable question. Is it possible that an entirely innocent, well-meaning, but perhaps just slightly disorganized landlord could stumble face first into this web of 30,000-pound fines, 12-month rent clawbacks, and hostile government takeovers purely through administrative incompetence?
But it's a very real possibility.
If you miss a licensing renewal deadline by a week, or, I don't know, don't understand the exact square footage requirements for a single bedroom in an HMO,
Yeah.
suddenly you aren't just disorganized.
Yeah.
In the eyes of the law, you are effectively a criminal facing ruin. It really makes you question the dangerously thin line between being a true rogue and simply being overwhelmed by the modern bureaucracy of property law. Next time you pass a to let sign, remember, it isn't just a house, it's a potential legal minefield just waiting for someone to step on the wrong square.